So, a very warm good morning to all of you. Now, let's just start today's discussion. If you people haven't subscribed to our channel till now, please go and subscribe to the channel and don't forget to press the bell icon. So, whenever me or any of the faculties are coming live, you will get the notification of the same. And if you people haven't checked out MP Civil Judge Prelims Crash Course, just do check it out. Link is in the description box. Now, today we are planning to discuss MP Civil Judge 2017 question paper, in which we are planning to discuss from question number 21 to 50, in which we are going to discuss CPC, Indian Contract Act, Transfer of Property Act, and Limitation Act. So the first question for the day is question number 21, that is, an executing court. Option 1 can go behind a decree. Option 2 cannot go behind a decree. Option 3 it depends on discretion of the court, and option 4 none of these or none of the above. So what should be the correct answer? This particular question is from your order 21 of CPC. So an executing court, option 1 can go behind a decree. Option 2 cannot go behind a decree. Option 3 it depends on the discretion of the court, and 4 none of these. What should be the correct answer? Yes, anyone? So its correct answer will be that an executing court cannot go behind the decree. So 21 ka yes, 2 is the correct answer, Vinny ji. Question number 22. In which proceedings rule 3, 4 and 8, yes Harshvardhan ji, 21 ka B is the correct answer. Question number 22. In which proceeding rule 3, 4 and 8 of order 22 of CPC shall not? Option 1 shall not be applicable, right? So option 1 civil suit, option B civil appeal, option 3 miscellaneous appeal, and option 4 execution of decree. So they are stating that rule 3, 4 and 8 of order 22 of CPC. Yes, Ankita Gupta ji, 21 ka B is the correct answer. So in which proceeding rule 3, 4 and 8 of order 22 of CPC shall not be applicable? First civil suit, second civil appeal, third miscellaneous appeal, and fourth execution of decree. So order 22 rules are not applicable in the cases of civil suit, civil appeal, miscellaneous appeal, execution of decree. What should be the correct answer? Hanji, its correct answer will be your option 4, that is execution of decree. Yes, Vinny ji, you are correct. Ankita ji, it will not be 2, it will be 4. Question number 23. No preliminary decree is passed. No preliminary decree is passed. Option 1, in a partition suit. Option 2, in a suit seeking specific performance of sale agreement. Option 3, in a suit seeking relief of foreclosure. Option 4, in a suit seeking relief of redemption. So no preliminary decree is passed. Option 1, in a partition suit. Option 2, in a suit seeking specific performance of sale agreement. Option 3, in a suit seeking relief of foreclosure. And option 4, that is in a suit seeking relief of redemption. What should be the correct answer? Yes. Question number 23. If you will read order 20, rule 12 to 18, there you will simply find the cases in which preliminary decree can be passed. So in which of the following cases we can say that preliminary decree cannot be passed? What should be the correct answer? Yes. In a partition suit, in a suit seeking specific performance of sale agreement, in a suit seeking relief of foreclosure, and last one, in a suit seeking relief of redemption. What should be the correct answer? Question number 23. Yes, its correct answer is 4. That is, in a suit seeking relief of redemption. In those cases, no preliminary decree can be passed. Next question is question number 24. Right to lodge caveat is provided under the provision of. Right to lodge caveat is provided under. Yes, Ankita ji, 23 ka D is the correct answer. Right to lodge caveat is provided under the provision of option 1, section 87A of CPC, option 2, section 87B of CPC, option 3, section 135A of CPC, and option 4, section 148A of CPC. What should be the correct answer? What should be the correct answer? Right to lodge caveat is provided under the provision of 87A of CPC, 87B of CPC, 135A of CPC, and section 148A of CPC. So it is provided 24 ka yes. Fourth is the correct answer, Harshvardhan ji. That is section 148A. Next question. Question number 25. Yes, Ankita Gupta ji, 24 ka D is the correct answer. Question number 25. The clerical or arithmetical mistakes in judgments, decrees, or orders from any accidental slip may be corrected by the court under which section of CPC? Option 1, section 151. Option 2, section 152. Option 3, section 153. And option 4, section 144. What should be the correct answer? Clerical or arithmetic mistakes in judgments, decrees, or orders from any accidental slip may be corrected by the court under which section of CPC? 151, 152, 153, 144. What should be the correct answer? Yes, its correct answer is 152. 25 का 2 is the correct answer. Yes, Harshvardhan ji, you are correct. चलिए आगे बढ़ते हैं. Now, next question is your question number 26. Under section 3 of Transfer of Property Act, an instrument is defined as. Under section 3 of Transfer of Property Act, an instrument is defined as. Option 1, a testamentary instrument. Option 2, a non-testamentary instrument. Option 3, an official document. And option 4, all of them. No, Ankita Gupta ji, 25 ka first will not be the correct answer. 25 ka second will be the correct answer. Right? Now, it is defined not under section 151. It is defined under section 152. So under section 3 of Transfer of Property Act, an instrument is defined as a testamentary instrument, a non-testamentary instrument, an official document, and all of the above, or all of them. What should be the correct answer? Question number 26. This is your first question from Transfer of Property Act. So 26 ka 2 is the correct answer. That is a non-testamentary instrument. If you will read the definition clause of your Transfer of Property Act 1882, you can simply get the presumption that under section 3 of Transfer of Property Act, an instrument defined as a non-testamentary instrument. Next question is question number 27. Now, before you answer question number 27, read it carefully. Whether co-owner of immovable property can transfer his share without partition. Option 1, he can transfer his share but not a particular portion of immovable property. Option 2, he cannot transfer his share without partition. Option 3, he can transfer his share as well as particular portion of immovable property. And option 4, none of the above or none of these. What should be the correct answer? Question number 27. If you people have read section 44, that is transfer by one co-owner, then you will be in the position to answer this particular question. Question number 27. What should be the correct answer? Yes, 27. Question number 27, first is the correct answer, that he can transfer his share but not a particular portion of immovable property. This is what is stated under section 44 of Transfer of Property Act, that is transfer of property by one co-owner, right? So 27 ka first will be the correct answer. Right? Next question. Question number 28. Again from Transfer of Property Act. Does agreement to sale convey title to the purchaser? Agreement to sale convey title to purchaser. Option 1. No. Intending purchaser has right to get conveyance in terms of agreement. Option 2. Yes, if intending purchase has paid the full consideration. Option 3. Yes, if attested. Option 4. Does not provide any right. So they are asking about the agreement to sale. So agreement to sale convey any title to the purchaser. Option 1. Not intending purchaser has right to get conveyance in terms of agreement. Option 2. Yes, if the intending purchaser has paid full consideration. Option 3. Yes, if attested. Option 4. Does not provide any right. Question number 28. What should be the correct answer? Yes. Question number 28. What should be the correct answer? Its correct answer is your first option, that is no. Intending to purchase has right to get conveyance in terms of agreement, right? So 28 ka first is the correct answer. Even this particular question was disputed because lots of students were thinking this question is from Sales of Goods Act rather than Transfer of Property Act. Next question, question number 29. A gift comprises both the existing and future property is. A gift comprises of both. Nahi Ankita Gupta ji, 28 ka 3 nahi hoga. Answer will be first. A gift comprises of both existing and future gift is. Option 1, void as to the first part only. Option 2, void as to the second part only. Option 3, void as to both of the parts. And fourth, not void at all. What should be the correct answer? Yes, question number 29. What should be the correct answer? Can anyone tell me? It's quite easy question from gift wala section. All of you would have followed up this particular provision. Under section 124 of Transfer of Property Act, what should be the correct answer? So its correct answer will be 29 ka 2. Yes, Ankita ji, its correct answer will be 2. That gift is void as to the second part only, right? That is of future gift. Next question, question number 30. Whether a Hindu person can gift his immovable property orally. Option 1, yes, if possession is delivered. Option 2, no. Option 3, it depends upon the discretion of donee. And after option 4, none of these or none of the above. Now, whether a Hindu person can gift his immovable property orally. 29 ka yes, Harshvardhan Gautam ji. Second is the correct answer. 30. Whether a Hindu person can gift his immovable property orally. Option 1, yes. If possession is delivered. Option 2, no. Option 3, it is discretion of the donee. Excuse me. And after option 4, none of these or none of the above. So what should be the correct answer? Question number 30. Now, if you people have followed up section 123 of Transfer of Property Act, it simply says that the gift should be a registered instrument. So accordingly, we can say that second is the correct answer, that is no. Yes, legal knowledge, 2 is the correct answer. Question number 31. Ankita Gupta ji, 30 ka 2 is the correct answer. Harshvardhan Gautam ji, 30 ka 2 is the correct answer. Next question. Question number 31. Who may sue for redemption? Who may sue for redemption? Option 1, mortgager. Option 2, mortgagee. Option 3, both of them. And option 4, none of them. Mortgager, mortgagee, both of them, none of them. Who may sue for redemption? Now, before answering this question, try to figure out what is redemption, what is foreclosure, mortgager, and mortgagee. What all roles all these four parties are having. So if you will read like section 60 of Transfer of Property Act, you can easily answer that. Its correct answer should be that the mortgager is the one who may sue for redemption. Yes, legal knowledge ji. One is the correct answer, right? Ankita Gupta ji, not mortgagee, it's mortgager. Okay, mortgager is having right to redemption, not the mortgagee. Okay, here you have to understand who is going to redeem. Redemption कब होता है? Property redemption का मतलब होता है property वापस लेना. तो mortgager ने ही तो property दी है, तो वही तो वापस redeem करेगा. mortgagee के पास तो already है ही, उसे redeem करने की क्या जरूरत है? Understanding the point over here? चलिए next question. Question number 32. Which of these modes an actionable claim can be transferred? By which of these modes an actionable claim can be transferred, right? So by which of these modes an actionable claim can be transferred? Now you can read the options. Like first, by registered instrument. Option 2, by an execution of instrument in writing signed by the transferor. Option 3, by an instrument attested by two or two witnesses. Option 4, by all of them. So by which of these modes an actionable claim can be transferred? Question number 32. Yes, what should be the correct answer? 34 ka 4 will not be, 32 ka 4 will not be the correct answer. Rather than its correct answer will be 2. That is, an actionable claim can be transferred by execution of instrument in writing signed by the transferor. So 32 ka 4 is the correct answer, not 4. Why you people are resisting on 4? Because when you are transferring an actionable claim, it is not necessary that it has to be attested by two or more witnesses, right? So its correct answer will be 2. Next question, question 33. This particular question is from Indian Contract Act. A contract with or by minor is. A contract with or by minor is. Option 1, valid. Option 2, void. Option 3, voidable. Option 4, voidable at the option of either party. Question number 33. A contract with a minor is valid, void, voidable, valid, void, voidable, voidable at the option of either party. Legal knowledge, try to write the question number as well. 33. Yes, Ankita ji, you are correct. 33 ka. Harshvardhan ji, you are also correct. Its correct answer will be void. Any contract with a minor is void ab initio. Next question, question number 34. In which case fraud is committed by silence? In which case fraud is committed by silence? Option 1, A did not disclose B at the time of selling his car that he had the stolen car. Option 2, A did not tell the B at the time of selling wheat about the quality. Option 3, A did not let B know that the price of gold is likely to fall at the time of selling gold to him. Next question, A did not reveal B at the time of selling that the new edition of book has already published. Question number 34, thoda sa lengthy hai. Take your time, read the question properly and then answer it. So, like, I'm sure all of you must be aware about fraud. An active concealment of fact can be considered as fraud, not the passive concealment of fact. So out of these four options, which option you feel that there is an active concealment of fact? Question number 34. Just let me know. Yes, question number 34. It's correct answer. Ankita ji is saying 3. What about others? 34. What should be the correct answer? Harshvardhan Gautamji is saying 1. Yes, 1A is the correct answer, because ideally the person cannot assume that the car is a stolen car, right? But when we are talking about the quality of wheat or gold is likely to fall, or like the new edition of book has been published, all of these things, here the caveat emptor means let the buyer beware principle should be applicable. But in this case, let the buyer beware will not be applicable, and it is the liability of the seller to disclose that the car is theft one. Okay? Stolen one. Next question. Question number 35. An agreement to sell goodwill for a specified area to which purchaser agreed is option 1 void, option 2 voidable, option 3 valid, option 4 none of these or none of the above. Question number 35. An agreement to sell goodwill for a specified area to which the purchaser agreed. Option 1 void, option 2 voidable, option 3 valid, option 4 none of these or none of the above. So question number 35, what should be the correct answer? An agreement to sell the goodwill for a specified area to which the purchaser is agreed is option 1 void, option 2 voidable, option 3 valid, and option 4 none of these or none of the above. What should be the correct answer? 35, Ankita ji is saying 2 voidable. Why voidable, Ankita ji? Just let me know. Is there any specific reasoning you are applying behind it? If you people will read section 27 of Indian Contract Act 1872, you can easily derive this conclusion. Vinny ji is saying 3, that is valid. Okay. I was stating if you will apply section 27 of Indian Contract Act, you can easily derive the conclusion that an agreement to sale, like an agreement to restraint of trade is void, but to sale of goodwill for a specified area is valid, right? So its correct answer will be 3. Next question, question number 36. A contract is void if option 1, it is caused by fraud, option 2, it is caused by coercion, option 3, its consideration is unlawful, option 4, all of these or all of the above. So what should be the correct answer? A contract is void if option 1, it is caused by fraud, option 2, it is caused by coercion, option 3, its consideration is unlawful, option 4, all of these or all of the above. Question number 36. What should be the correct answer? A contract is void if it is caused by fraud, if it is caused by coercion, if its consideration is unlawful, and all of these. Okay, Vinny, why you are applying the logic of all of these? Let me just know. Any specific reasoning you have applied over there? Harshvardhan Gautamji, 36 ka 4. There is a slight problem. I think there's a slight problem with the concept. If you people are aware that a contract caused by fraud, undue influence, mistake, misrepresentation, or coercion, all these contracts are voidable, not void, at the option of aggrieved party. And if you will read your section 23 of Indian Contract Act, it simply says that if the consideration is unlawful, then the contract is void. Even under section 10 also the same thing has been discussed. So its correct answer should be option 3 rather than it will be like 4, right? So its correct answer is option 3, right? Question number 37. A contract is not void if it is made. A contract is not void if it is made, option 1, in restraint of marriage of a person not being minor. Option 2, in restraint of trade if the goodwill of the trade is not sold. Option 3, by way of wager. Option 4, to pay a time barred debt. Now here they are asking which of the following contract is not void. So in simple you can say they are asking a contract is valid if it is made. Not void matlab valid. So a contract is valid if it is made. You have, like in question number 37, they have played with the language of the provision, language of the question. So what should be the correct answer? Question number 37. If you people have read section 25, it simply says an agreement without consideration is not valid except the cases of gift, and the second one is to pay a time barred debt. So what should be the correct answer? Just let me know what should be the correct answer of this question. Hanji, a contract is not voidable if it is made. So Ankita Gupta ji, you are saying that if we are making a contract by way of wager, that means a wagering agreement is lawful. It is valid. Ankita Gupta ji is again saying to pay a time barred debt. Okay. Yes. Vinny ji is saying 37 ka R. R? Okay. Probably there must be some typo. So its correct answer is 4. Yes. Yes, Vinny ji, you are also correct. Ankita ji, you are also correct. Its correct answer is to pay a time barred debt. So this particular type of contract is not void. Next question, question number 38. A employs B to beat C and agrees to indemnify him against all the consequences of the act. B thereupon beats C. B is sued for the damages by C. Which is the correct in the given option? Which is the correct in the given option? Option 1. A is liable to indemnify B for those damages. Option 2. Only A is liable to C to pay those damages. Option 3. A is not liable to indemnify B for those damages. And option 4. None of the above or none of these. Question number 38. A is liable to indemnify B for those damages. Only A is liable to pay C to those damages. Next, A is not liable to indemnify B for those damages. And option 4, none of these or none of the above. What should be the correct answer? Question number 38. Yes. 38 ka what should be the correct answer? A employs B to beat C and agrees to indemnify him against all the consequences of the act. So, yes, Viniji, its correct answer will be 3. That is, A is not liable to indemnify B against those damages. The reason is there is an agreement to do an illegal thing, unlawful thing. Okay? Next question, question number 39. A contract of indemnity is defined under which section of Indian Contract Act? Contract of indemnity is defined under which section of Indian Contract Act? Option 1, section 124, option 2, section 125, option 3, section 126, and option D or option 4, section 127. Question number 39. What should be the correct answer? Contract of indemnity is defined under which section? 124, 125, 126, 127. अगेन डायरेक्टली बेयर बेस्ड क्वेश्चन है, प्रोविजन नंबर पूछा गया है आपसे. कॉन्ट्रैक्ट ऑफ इंडेमनिटी इज डिफाइंड अंडर विच सेक्शन? हाँ जी, आई एम एक्सपेक्टिंग अ आंसर. विनी जी 39 का 1. यस, हमारे प्रोविजन एक्सपर्ट कहाँ है अंकिता जी? जो हमेशा सारे प्रोविजंस को याद रखते हैं, यस इट्स करेक्ट आंसर इज सेक्शन 124। चलिए नेक्स्ट क्वेश्चन, क्वेश्चन नंबर 40, द प्रोविजन विच प्रोवाइड्स for compensation for loss or damage caused by breach of contract is provided in the provision which provides for, yes Harshvardhan ji, Ankita ji, both of you are correct, the provision which provides for compensation for loss or damage caused by breach of contract is provided in option 1 section 51 of Indian Contract Act, option 2 section 63 of Indian Contract Act, option 3 section 73 of Indian Contract Act, and option 4 section 125 of Indian Contract Act. So which of the following section provides compensation for long or loss or damage caused by breach of contract? So this particular thing is provided under which provision? 51, 63, 73, 125. Which provision of Indian Contract Act provides for the same? Again प्रॉपर बेयर एक्ट बेस्ड क्वेश्चन है, क्वेश्चन नंबर 40। इट्स करेक्ट आंसर विल बी यस सेक्शन 73 ऑफ इंडियन कॉन्ट्रैक्ट एक्ट। हर्षवर्धन जी यू आर करेक्ट, इट्स करेक्ट आंसर इज सेक्शन 73 ऑफ इंडियन कॉन्ट्रैक्ट एक्ट। अंकिता गुप्ता जी यू आर ऑल्सो करेक्ट। नेक्स्ट क्वेश्चन, क्वेश्चन नंबर 41, अंडर सेक्शन 6 ऑफ स्पेसिफिक रिलीफ एक्ट। अब देखिए ये क्वेश्चन आपका आ गया एसआरए से। अंडर सेक्शन 6 ऑफ स्पेसिफिक रिलीफ एक्ट, इफ एनी पर्सन इज dispossessed without his consent of immovable property otherwise than in due course of law to recover possession, option 1 he has to prove the title, option 2 he has to prove his prior possession, option 3 he has to prove both the title and prior possession, and option 4 none of these or none of the above. Now all those who are attending these classes like from past few days, तो ये क्वेश्चन ऐसा है जो बहुत फ्रीक्वेंट रिपीट हुआ है ऑलमोस्ट इन ऑल द इयर्स। ठीक है, सेक्शन 6 ऑफ एसआरए से क्वेश्चन ना बने ऐसा हो ही नहीं सकता एमपी के एग्जाम में। 41 का विनी जी सेइंग 2, यस विनी जी 2 is the correct answer, that he has to prove his prior possession, that will be sufficient. That particular person does not require to prove anything more than that, right? So section 6 of specific relief act mein when a person has been dispossessed he has to prove his prior possession, right? Next question, question number 42, in order to succeed in the suit for specific performance of a contract for sale, the plaintiff has to aver and prove that, option 1 his readiness and willingness to perform the contract, option 2 only his readiness to perform the contract, option 3 his willingness to perform the contract, option 4 only his potential to perform the contract. So when a particular party is looking for a specific performance in a contract of sale, okay, the plaintiff has to prove what he has to prove, his readiness and willingness to perform the contract, option 2 only his readiness to only his willingness to perform the contract, only his readiness to perform the contract, and the last option is only his potential to perform the contract. Yes Harshvardhan ji is saying 42 ka 1, yes Harshvardhan ji 42 ka 1 is the correct answer. Now what should be the correct answer of question number 40? Yes 42, okay 42 ka 1 is the correct answer, yes both of you are correct, Harshvardhan ji, Vinny ji. Chaliye, let's move further. Next question, question number 43. Ankita Gupta ji, 42 ka 1 is the correct answer. Question number 43. An instrument is not settlement under specific relief act. So if you will read the definition clause, that is your specifically section 2b of like specific relief act, there you will find the answer of this question. An instrument is not settlement under specific relief act, option 1 where an interest in the property is devolved by will, option 2 where devolution of an interest in a movable property is disposed of, option 3 where devolution of successive interest in an immovable property is disposed of. Option 4, where devolution of interest in an immovable property is only agreed to be disposed of. So which of the following cannot be considered as settlement? Now, if you will read section 2B of Specific Relief Act, it simply says that an instrument is not a will, okay, where the interest in the property is devolved by will or codicil, right? So its correct answer, question number 42. Question number 43, what should be the correct answer? So when our interest and the property is devolved by will or codicil, it cannot be considered as settlement, right? As per section 2B of Specific Relief Act. So what should be the correct answer? Question number 43. हाँ जी, क्वेश्चन नंबर 43 का क्या होगा करेक्ट आंसर? Its correct answer is option 1. That is, where an interest in the property is devolved by a will. Right? चलिए. Yes, Harshvardhan ji, Ankita ji, both of you are correct. Good going. चलिए. Next question. Question number 44. A plaintiff in a suit based on contract for sale may seek the relief of rescission of contract. Now, if you will read the term rescission of contract, this is defined under your section 26 of section 26 of Specific Relief Act. Okay. While if we will specifically talk about this particular problem, so this particular problem is addressed under your section 27 of Specific Relief Act. Okay. A plaintiff in a suit based on contract for sale may seek the relief of rescission of a contract. Option 1. In alternative to the relief of specific performance. Option 2, even after the decree of specific performance under certain circumstances. यहाँ पे ये बीच में gap नहीं है, it will remain same. So under certain circumstances. Next, option 3, if it is voidable by him. Option 4, in all of the above cases or all of them. Question number 44. So what should be the correct answer? Question number 44. If you will read under section 27, there are certain conditions in which the rescission may be adjudged or refused. So when like the remedy of rescission may be given under under Specific Relief Act. In alternative to the specific performance. Option 2, even after the decree of specific performance under certain circumstances. Option 3, if it is voidable by him. Option 4, all of them. 44. Harshvardhan Gautam ji is saying if it is voidable by him. Yes. What about others? I will suggest you people to read the bare provision of SRA. एक चीज याद रखिए, कॉन्ट्रैक्ट एक्ट में आपको बहुत कुछ पढ़ना पड़ेगा, देन यू विल सिक्योर 8 मार्क्स. टीपीए में यू हैव टू स्टडी अ लॉट, देन यू आर गोइंग टू सिक्योर योर 7 मार्क्स, बट नॉट द केस विथ योर SRA. SRA छोटा एक्ट है, इफ यू विल रीड इट थरोली यू कैन इजीली स्कोर 6 मार्क्स. So 44 का correct answer is D, that is in all of these, all of the above cases, right? So in all of these cases, the plaintiff may seek for rescission of a contract. Now, next question, question number 45. The jurisdiction to decree of specific performance is discretionary and the court is not bound to grant such relief merely because it is lawful to do so. These words are taken from which section of Specific Relief Act? Question number 45. Option 1, section 19. Option 2, section 20. Option 3, section 21. Option D, section 22. So 19, 20, 21, 22. These are the options available with us. Question number 45. What should be the correct answer? Yes. The jurisdiction to decree of specific performance is discretionary and the court is not bound to grant such relief merely because it is lawful to do so. These words are taken from which section of Specific Relief Act? Section 19, 20, 21, 22. Question number 45. What should be the correct answer? Question number 45. Haji. 19, 20, 21, 22. So which particular provision is talking about this thing? That the jurisdiction to decree of a specific performance is discretionary and the court is not bound to grant such relief merely because it is lawful to do so. This particular statement is taken from which particular provision of Specific Relief Act? So its correct answer will be your option 2, that is section 20. Right? Again, that is a Bare Act based question. Next question, question number 46. Under section 39 of Specific Relief Act 1963 is related with. Section 39 of Specific Relief Act is related with option 1, effect of declaration, option 2, temporary injunction, option 3, perpetual injunction or permanent injunction, option 4, mandatory injunction. So section 39 of Specific Relief Act is related with option 1, effect of declaration, option 2, temporary injunction, option 3, perpetual injunction, and option 4, mandatory injunction. Yes, Ankita Gupta ji, 45 ka 2 is the correct answer. Question number 46. What should be the correct answer? Under section 39 of Specific Relief Act, this particular provision is related with effect of declaration, temporary injunction, perpetual injunction, and mandatory injunction. What should be the correct answer? Question number 39. Harshvardhan Gautam ji is saying 39 ka 4. Okay, 39 ka Harshvardhan ji first is the correct answer. 46 ka zarur fourth is the correct answer. That is mandatory injunction. So, if we will simply talk about temporary injunction is defined under 37, perpetual injunction 38, and mandatory injunctions are defined under your section 39. So 46 का correct answer will be your option 4, right? चलिए अंकिता गुप्ता जी 46 का 2 नहीं 2 नहीं होगा because temporary injunction is defined under section 37. अंकिता जी question number 47. Section 5 of Limitation Act applies to. Section 5 of Limitation Act applies to option 1, suits, option 2, execution of decrees, option 3, appeal and application, option 4, all of these or all of the above. Yes, Ankita Gupta ji, 46 ka 4 is the correct answer. Now, section 5 of Limitation Act applies to. देखिए जैसे SRA में section 6 है ऐसे ही Limitation Act में section 5 है. MP सेक्शन 5 ऑफ लिमिटेशन एक्ट से क्वेश्चन ना पूछे इसके चांसेस बहुत लो होते हैं. सो सेक्शन 5 ऑफ लिमिटेशन एक्ट अप्लाइज टू ऑप्शन 1, सूट, ऑप्शन 2, एग्जीक्यूशन ऑफ डिक्रीज, ऑप्शन 3, अपील एंड एप्लीकेशन, ऑप्शन 4, ऑल ऑफ द अबव और ऑल ऑफ दीज. क्वेश्चन नंबर 47. व्हाट शुड बी द करेक्ट आंसर? हाँ जी, सूट्स, एग्जीक्यूशन ऑफ डिक्री, अपील एंड एप्लीकेशन, एंड all of the above, all of these. This is your first question from Limitation Act, question number 47. Now, if you will read proper provision of section 5 of Limitation Act, it simply says that section 5 of Limitation Act does not apply to suit, execution of decrees, and an application made under Hindu Adoption and Maintenance Act. So it simply means that section 5 of Limitation Act is applicable on appeal and application. तो हर्षवर्धन गौतम जी का आंसर बिल्कुल सही है. अंकिता गुप्ता जी नहीं, all of these नहीं होगा because section 5 of Limitation Act does not apply to suit and an application made under order 21 of CPC. Order 21 of CPC means execution of decree. So in these two cases it is not applicable. So its correct answer is 3. Next, question number 48. This is like probably one of the most challenging question I felt in person in the whole question paper. Question number 48. In which section it is provided that in computing the period of limitation for appeal, review or revision, the time requisite for obtaining the copy of decree or order appealed shall be excluded under Section 12 subclause 1, Section 12 subclause 2, Section 13 subclause 3, Section 14 subclause 4. Now, all those people who have read Limitation Act closely will be noticing it, that time requisite for obtaining the copy of decree or order. Time requisite for obtaining the copy of decree and order. This is the particular thing, because if you will read your particularly section 12 में 1 2 3 4 करके काफी सारे points हैं which are stating various things. Time requisite for obtaining the copy of judgment, time requisite to file an appeal, time requisite to obtaining a copy of decree or order. तो वहां पे like you have to be very much clear in your mind, क्योंकि उन्होंने इतना deep में दे दिया है 12 subclause 1, 12 subclause 2, right? But if you will apply common sense to 12 subclause 1 होने के chances खत्म हो जाते हैं, because ideally subclause 1 provides you the general definition. So its answer, what should be its correct answer? Question number 48. Yes. If you will apply common sense and if you remember कि हाँ भाई section 12 में ही time requisite वाले सारे provision हैं, तो 12 subclause 1 is eliminated. Option 3 and 4, that is talking about 13 and 14, are also eliminated. So its correct answer should be 12 subclause 2, right? 48 ka the correct answer is 12 subclause 2. Now, next question. Question number 49. Which among the following is not legal disability under Section 6 of Limitation Act 1963? Which of the following is not a legal disability under Limitation Act 1963? Sorry. Okay. Option 1, imprisonment. Option 2, idiocy. Option 3, minority. And option 4, insanity. So which of the following is not a legal disability? Imprisonment, idiocy, minority, insanity. What should be the correct answer? Question number 49. Which among the following is not a legal disability under Section 6 of Limitation Act 1963? Imprisonment, idiocy, minority, insanity. Question number 49. Hanji. Its correct answer, Harshvardhan Gautamji is saying first. Okay, very good. Now, if you will read Section 6, so definitely idiocy, minority, and insanity, all these three are the ground of disability, right? So its correct answer is 1, that is imprisonment. So Harshvardhan Gautamji, Ankita ji, both of you are correct. Next question, question number 50. Limitation to file suit for possession of immovable property. Limitation to file suit for possession of immovable property is option 1, 1 year, option 2, 3 year, option 3, 12 year, option 4, 30 year. So limitation to file a suit for possession of immovable property is option 1, 1 year, option 2, 3 year, option 3, 12 year, and option 4, 30 years. What should be the correct answer? Question number 50. Hanji. Now, if you are aware that in majority of the cases of immovable property, usually the limitation period goes to 12 years, except some of the cases like foreclosure, redemption, there the limitation period may go up to 30 years. Otherwise, generally it goes to 12 years. So its correct answer is yes, Harshvardhan ji. It should be option 3, that is 12 years. Now, if you people have attended the session till now and if you find it informative for you, don't forget to like the video, okay, and to subscribe to the channel of Rostrum Legal. Yes, Ankita Gupta ji, 50 ka 3 is the correct answer. We are putting lots and lots of efforts to come up with such a substantial knowledge for you people. Don't forget to like us and to subscribe to our channel. And at the same time, if you people haven't checked out MP Civil Judge Prelims Crash Course, just do check it out. Link is in the description box, in which we are providing you 10+ mocks, which is surely going to enhance your 5 to 7 to 10 marks in your MP Civil Judge Prelims. These mocks are very much updated, focusing upon the latest pattern of MP Civil Judge exam. See you people tomorrow in the next class with some new discussions. Meanwhile, take care. Thank you, Harshvardhan ji. Thanks to all of you. Right? Take care. Bye-bye.